already lost control here. So I'll just take over. First thing I'm going to do is to let each individual either or the proposition, so we kind of know where they're coming from.
So, just to clarify who everybody is, this is Dan Curley. He's counsel for the college. He's going to act as our moderator today to the extent that this is a group that's easily moderated. And essentially the proposition is this, that the U.S. Constitution is out of date. My support or opposition to, I disagree. I do not think that the Constitution itself is outdated. I think that there are forms of interpretation of the Constitution that are vastly, massively outdated.
Okay. And your position?
I would have to that people are but the way that it's written is just misunderstood from founding fathers.
Okay. Greg?
I thought they would have more for me to disagree with at this point. I would say that in order for the Constitution to be outdated, it would have to have been dated in the first place.
It does have a date on it.
Yeah. I think the question is, does the Constitution still hold up? And what I would say is that if we're reverse engineering the document to try to get things like liberty, equality, and democracy, we didn't create the right institutions in the first place. So something can't be outdated if it was never appropriate for our goals in the first place.
Okay, well.
Boom! Way to dodge the question.
Yeah. That's politics.
Is that a yes or a no?
That's a dodge.
It's a kind of it's hard to dodge. It's hard to
Dodge. All right. That's okay. Harold?
Well, I don't think the Constitution is outdated. I don't at all by any stretch of imagination.
Thank you. I'm going to go on the side that it is outdated.
Okay.
That the, although I do completely hate the term founding fathers, as I think it is a mythologizing of people who are not to be mythologized. I think that I will use the example I told to Daryl earlier today, that if we were to go and dig up all the founding fathers and use our technology to resurrect them as zombies, get over their instinct to eat our brains, and then teach them to read and write and have all their history and all that type of stuff. If we do all those things and then we ask them where we, show them where we stand today, their answer would be, why in the world are you still using this that we created back then to govern a country in 2022? That's my contention on it.
Okay.
The zombie contention.
Zombie Franklin would be fun.
Yeah, it depends on which age, I mean, by the end of it though, I mean, you need him kind of like middle-aged, yeah.
All right, so we've got mostly no's, one yes. So is it a function of the way it was conceived, or is it a function of the is it a systemic problem or a conceptual problem?
Well, systemically, there is no constitution for people of color and women. We're just amendments. So there is a systemic problem.
Under the Constitution, an amendment becomes integrated as part of the Constitution. So does that give you a position?
Well, the problem there is that amendments can be repealed. So the rights that we were given, either people of color, of different genders, there can be a repeal at any point if the Congress has the majority and has the ability to do so. The Constitution, the original Constitution, you don't amend that. Any amendment, it can be changed. Any amendment that is to change the original can then be changed. So it's an issue of nothing in the Constitution is permanent. I have an issue with that, and that is both a conceptual and a systemic issue.
Okay, what is the conceptual issue?
The fact that it can be amended. Whenever it was created in a way that said, by these rules, Congress can change things that we have already set into place. That is the issue whenever it comes to slavery, 3/5 compromise, women having the right to vote, prohibition. All of these things are changes that took place, and in a conceptual way, anything can be changed. In a systemic way, we're allowing them to be changed.
Jerry?
This is where this gets complicated, right? Because we should start with what we want, right? Start with the outcome that we want and reverse engineer a government that fits that. If truly what we want is equality, democracy, right, this liberty that we talk about, that all of us talk about in our classes, and you have to sit there and listen to us bloviate on about, if we want to achieve those, then we need to reverse engineer systems and institutions that do that. You're talking about we can make changes to, or you said, I suppose, were amendments. That's fine, right? But when you make that's this many amendments to something, come out with version 2.0, right? Medical companies, pharmaceutical companies come out with new pills like, oh, this one doesn't give you gas, and they charge you twice as much. Can we not write a new constitution that addresses the current issues of 2022 in this world where we now have the thing called the internet that the founding fathers, well, Franklin may have thought about it, but, right? We do not have a system that is built to realize those ideals. So I think we just need to start over, quite frankly.
Well, and I'll follow up on
Yeah.
that from the historical perspective. I mean, just look at what Jefferson says later on in his life about it, that a government should be completely rethought and even revolutionized about once a generation, because you can't possibly create something that is going to then apply to the people afterwards. And the other thing, at least historical context-wise, that I always think of is the Constitution's their second try to make a government. They saw the first one fail, and there is, I mean, I will say there's nothing in the Constitution that says it is perpetual and forever. There's also nothing that says it's not perpetual and forever. I mean, they leave that open, which to me leaves open the possibility of this may last as long as the Articles of Confederation government did, and then we're going to have to all get together and come up with something else. So that both sides of it, both what somebody in Jefferson would say, but also just you look at what happened in history, it's not permanent.
Kind of brings into,
Let me interject for a second.
and you'll get your chance. The idea is whether or not certainty or flexibility are compatible. And do we need something that is a fixed point, or do we need something that needs to be malleable and meet the moment without having to rip it up and start over? When they did the Constitutional Convention, they had an opportunity to create that 2.0, and they really created 1.2 because they left the poison pills in it. So Darryl, what do you think about that?
Well, you have to get down to the basics about what the Constitution, any Constitution, is trying to create, and it's trying to create a fundamental basis for freedom, order, and equality. That's what it's trying to do.
There's some.
I'm not going to expound on your white privilege in this forum, but what
I had no idea.
But what I do.
You mean I'm going to stay this color?
Yeah, but what I do want to say though is that the framers of the Constitution, they created a document that was trying to create some fundamental values that we could base our laws on for, in my mind, forever.
Well, that it flies in the face of the fact that they provided for a way to change the Constitution.
Well, of course. I mean, and so from that regard, it's malleable, it's flexible, it's not a conservative saying that it's elastic. It can be. I think the framework is there. I certainly would be the last person on this panel to say that we need to scrap it and start all over.
No, you wouldn't be, because I agree with you. That's not, oh my God, I can't believe I said that out loud. I agree with Darryl.
Yes.
For the lightning. The argument that creating a Constitution 2.0 belies the fact that we have. That is, every amendment to the Constitution redefines the nature of the beast. I'm not overly excited that you can take away the protections that are created by amendments. But the flip side of that is the ability to take those things away allows for us to correct for political schisms that pop up from time to time, like prohibition, where we thought this was a great idea, it was a terrible idea, and we were able to correct that error without necessarily saying, start over. And more to the point, how do you start over in 2022? I mean, there's a practical political consideration. Half of us don't even agree whether or not the last election was valid. How in the hell are we going to agree on the content of the Constitution? It's not going to happen. We are kind of in the position of dealing with what we have laying in front of us. So if our concern is that the Constitution does not meet the times or whatever, is that actually true? Or is it that the interpretation of the Constitution is pinned to a point that doesn't make sense? Let's be blunt.
I agree with your second.
I mean, let's be blunt. Every time you hear the originalist argument or the textualist argument, that is a group of legal scholars, of jurists, who are basically being held hostage by ghosts. I am somehow obligated to always consider what was thought 200 years ago by people who owned people. That's the error.
We have their official mechanism to change the Constitution. We can have a convention, or we can have amendments. The unofficial one is judicial review.
You want to roll?
And the judicial review, if you're trying to be a textualist or an originalist, you say, where's the word? You don't find the word abortion, so you can't talk about it. You can't find the word privacy, so it's in question whether there is a concept of privacy that's protected by the Constitution. So, are we now in a place where the mechanisms at our disposal are not practical and they're not working for us?
Again, I think it depends on how that's interpreted.
Because judicial review is not in the Constitution.
No.
It is a precedent, and that's the issue, is that
it's the
Precedents
Constitution.
don't matter anymore.
It's the Supreme Court saying this is our job and so we're gonna do this.
Whenever the Constitution was first written, the job of the Supreme Court was not defined. It had zero power. And until 1803, whenever you had,
Marbury v. Madison.
Marbury v. Madison and Marshall
John
come in, always a John, my students know, is always a John. He comes in and he says, this is the job of the Supreme Court, and it is to check what this issue is against what the Constitution says. And judicial review is that precedent that Supreme Court, it's not set in the Constitution, this is their job. Marshall decides with the 4 other members of the Supreme Court, this is what our job is. So taking the logic that has been said here today, is judicial review even part of the Constitution, and should we still allow for that to happen?
Well, you answered your own question. And, that's a good way to go about it.
But you have to be careful about the way that he's phrased it. He doesn't just say it's our job. It is emphatically the province and duty of the judicial department to say what the law is. And I think it's that duty question that sort of frees us from the notion that this was just a job that they granted to themselves sort of without constitutional consideration. They're not only saying we're the appropriate branch to tell you what the law means. They're literally saying we have this obligation for obvious reasons. You can't have the legislature tell you what they meant. They're going to tell you what they meant, irrespective of whether that's real or not. You can't have the executive tell you what's meant.
Well, if they didn't have the power of review, would they be a branch?
That's where their power comes from. That's what Marshall was able to do, was to grant the power to the Supreme Court of checks and balances. Without judicial review, without the Supreme Court having that ability, there is no checks and balances. There's no way to perform that action.
But the Supreme Court has absolutely no enforcement mechanism. The Congress has the purse, the President has the sword. The Supreme Court has black robes. That's it. right? And paper, I mean, this kind of goes to my point here. We're sitting here trying to stretch and fit this thing that was written so long ago to fit the internet and abortion and privacy, right? We're saying, if it matters on what 9 people are sitting on the Supreme Court, maybe this is the problem, right? Maybe this is the issue, that this needs to be. If anybody in this room could sit down and write a new government right now, would you have 9 unelected people making decisions for your own body in a dark room that nobody gets to see what happens? Would anybody in this room design the Senate as it operates right now? Maybe if you're a masochist, but otherwise no, right? It's inefficient, it doesn't work. And
But
we're
that
sitting here
pers-
trying to
but
stretch
doesn't
this
that
and make
per-
it work.
But democracy itself, representative government, the republic they've created, was not meant to be efficient.
No, agreed, but not gridlocked and doing nothing.
But you're presuming that that's structural. That is,
Yeah.
that the reason
Yes.
the Senate functions the way it is because of the structure.
And not politics.
And
It's
not,
both.
and not, yeah, not,
The people of Montana love the way the Senate's set up. For those in Texas and California, we're a little angry about it, right? Yeah.
Depends on who's in charge.
Well,
Yeah.
And I mean,
Well,
that,
again, it's a systematic problem.
the other thing that comes back to, I mean, if you've got something like the filibuster in the Senate, then make them actually filibuster and not just say, you
And
can't
not
bring this
respond.
forward because I might theoretically filibuster.
We
this
need
at
more
some
Dr.
point in
Seuss
time.
in the Senate.
But the other thing is, I mean, if you look at, we're on this Supreme Court, the judicial review type thing. I mean, the Supreme Court is the one who told us that black people are not citizens and have no rights and should never appear in front of it.
and then they corrected themselves.
Yeah, but
My
separate but
question
equal after
is-
that, by
so
saying
like-
that they are people, but they can be
But-
separate as long as it's
Hang
equal.
on,
And
but
then they corrected that.
But I want to
Eventually.
be clear that it took a civil war to correct that.
Sure.
Dred Scott, the Dred Scott decision was in 52. I'm sorry?
57.
I'm sorry, you're right, 57. I just wrote this lecture too, I should know it. So in 57, by 67, you have the 14th Amendment. It takes 10 years, a war that kills almost 1 million people in order for the Supreme Court, the new Supreme Court, to say, oh wait, yes, they are people. They do have rights.
Right.
I understand that, but
So-
do you really want government to move fast?
I think there's too much emphasis on the first 100 days.
Well, I mean,
That's something that, whenever you're looking at, a new government comes in every 4 years. It doesn't matter if it's a new president or not. A new government comes in every 4 years by the way the Constitution has it set up. And there's so much emphasis on how much can they do in the first 100 days. And if they don't get that much done in the first 100 days, oh, it's going to be a lame duck presidency. And that's the prevailing, theory for the last 150 years. Before that 100-day emphasis, yes, Congress moved slow so they could understand what was going on. You also have to understand that things move so much faster now because we have the ability and technology to move
yes,
fast.
and it's done us such great
Daryl, do you remember the
political
days?
trial.
Before all that?
Yeah, I do.
So-
Remember, yeah.
It's, whenever you're talking about moving fast, you have to appreciate the technology today. You can send an email.
But that doesn't mean it's good.
I didn't say that. I said things are different. And
Sure.
you have to understand that the speed, the process, if the, I won't say founding fathers again, Scott. If the
Misogyny.
first generation of our government had the same technology as today, do you think they would move at a similar pace?
I don't know that I care.
Yeah, I mean,
Hear me out, I mean, I'm serious. I don't know that I care any more than I care whether or not they would have thought that cell phones were protected or not by the Fourth Amendment. That's my whole argument. I don't care what they think, because I can't know that. The best I can do is look at the historical documents and attempt to extrapolate some kind of sense of why it is that they felt X, Y, or Z thing then, and does that apply to now? And that ends up being the focus, instead of the pragmatic aspects of, should you be required as law enforcement to get a warrant to look inside somebody's phone that's locked? But for our understanding that the Fourth Amendment is written by whatever the hell we're gonna call these
First
people,
generation.
why do I care what they think? They never saw a cell phone. They would have thought it was witchcraft.
That's when you equate it to letters then, sealed letters.
Then you gotta have a Fourth Amendment. protection.
I think the easiest way to understand,
But that's not because they told you that letters apply. It's because it's rational legally to understand
Personal
that this is a personal. You don't need the founders to reach that conclusion.
in the Constitution, it doesn't say, private, or I'm sorry, privacy.
Says
Right, we've
unreasonable
established
search,
that.
unreasonable search and seizure.
Right,
Right.
and it's a personal property.
Right. But I don't need the founders to tell me.
What I'm trying to get at is the personal. You have to, in order to understand things from, 250 years ago to today, you have to find ways to equate it. Letters, cell phone. Personal is privacy.
If you don't need the Constitution to tell you that, and the founders do that, then why would we have
No, I didn't
Because
say you
somebody
don't
has
need
to be
the
able to point
Constitution.
to
I said I don't need the founders and what they thought to be the thing that defines whether or not in this situation it applies.
it? So what do you need?
I need the ability to legally rationalize what that
And
means.
and that's what you need the framework.
You need the
You
framework.
need the framework.
All right, so we've got two things that I've noticed. One is that we've talked about the different ways that the Supreme Court over time has interpreted the same document. Where they supported Dred Scott, they supported separate but equal. They corrected themselves, say.
8 years
So
later.
if we've seen these oscillations between progressive and conservative, what does that tell us about whether we should be patient or impatient with the current situation?
I talked
I'd say
That looked painful for
He's
Daryl.
Yeah,
That one's hurt
it's,
his brain.
I mean, from my conservative perspective, the republic is in great danger, and has been for the last 20 years.
What's the largest danger?
The largest danger is the cult of personality that both ideologies have perfected. You have Obama types on one side, Trump types on the other. Well, I understand that, but there's still a cult of personality around, that we developed that. I mean, there's
not
not.
Same thing with
been
Reagan.
ever thus, even when they were struggling over how to do the Constitution in the first place, you had anti-federalists who said, I want them foreigners over there telling me what to do, and I don't want anybody taxing me, I don't want anybody telling me think.
Just think if it's
I
true.
want to have my own freedom. So that tension of opposite points of view have been the environment that we worked with perpetually. I mean, was FDR, was he a personality cult?
Kennedy.
Kennedy,
Reagan.
Nixon.
Johnson, Jackson. I can take this all the way back. Cults of personality have been around since the beginning. So I disagree with that.
So to pretend that politics and personality are not major factors in the progress or the lack of progress in our federal system would be irrational, you think?
Yeah. Probably.
So can we design something that's a little bit more resistant to these changes in personality?
In
What
order
would
to
it look
do
like?
that, you have to remove the politics from it. And in today, in 2022, it is impossible to remove politics from any form of government. Absolutely impossible.
Or almost any damn thing.
For anything.
Sandwiches.
Well, let's look at the flexibility or inflexibility. In a past life, I was involved in information technology. And at that point in time, there was a big stress on having standards. And so the debate at that time was, if you have standards, is that a tether that kind of keeps you in one spot and it suppresses innovation and progress? And on the other hand, if you don't have a standard, what can you work to that is functional? So where's the balance between certainty and flexibility?
And based on what you just said, the Constitution does provide a tether. It is a tether.
But is it a tether to the wrong thing?
I don't think so.
Microphones.
I don't think so. No, it's not a tether to the wrong thing. I can't go that far. But it is a tether that we need. Otherwise, if we don't, then we're rudderless. We're just gonna be adrift.
I feel like we are already.
So we're clinging to this archaic anchor so that we don't get too far away from it? Seems reasonable.
Well, we also have a situation where.
We're tethered, yes, we're tethered to the
No, I'm
sinking
with
ship.
you. I
I
agree
mean,
with
we also
you.
have the situation where, I mean, the Constitution is created in secret session by 55 white guys, half of whom own slaves, who are creating this, and when they come out of the Constitutional Convention, the only option they give to the states is yes or no, and it doesn't even take a universal, everybody agrees, and it becomes the Constitution for the whole country. It just has to reach the 2/3 or 3/4, I never can remember because.
2/3.
Yeah, 2/3.
2/3.
And so we've got a constitution that to me is created as a mandate by a small group of people that this is what the country's gonna look like for centuries afterwards. Without, I mean, yes, they open up for the possibility of amendments and stuff like that afterwards, but it is presented as a fait accompli coming out of the Constitutional Convention that we've done it.
But nothing succeeds like success, right? I mean, it hasn't failed us yet.
Well, I think.
Yeah, Articles of Confederation was very popular initially
We're
too.
talking about the
What
Constitution.
I
But it
don't
hasn't
understand about that
failed us
though,
yet.
is that it wasn't an immediate acceptance, right? You had to have a compromise with the southern states, with the anti-federalists who said, no, we're not gonna support that unless you include these 10 amendments. So yes, go sign the Constitution, but automatically we need to change it.
Cool. Here's the thing, all those people are dead.
Yeah, that's my
Every
point.
single one of them.
So why are we
So my-
listening to them? They're dead.
Right, so my question is,
My
why,
point.
how does that discussion inform whether or not Twitter is a public space within the meaning of the First Amendment?
I'm saying the U.S. Constitution is completely out of date and has no relevance to Twitter whatsoever, and we need something else. That's what I'm saying.
But I'm not hearing why it is the Constitution can't answer that question.
Because if you're making something that's so vague that it is subjective to the whims of politics, then it's not helpful. That would be my argument.
But you can have something that's so concrete that it doesn't give you any.
I'm not saying write down like rules for bingo night at church, right? I'm saying
How
like
dare
have
you mention
slightly
church?
more,
By the way.
have slightly better guidelines in here than what we've got now, right? Try to build in basic protections for elections, right? I mean, we can do some basic things. Okay, I'm just soapboxing now, but.
Okay, so then I'll pose the question, should we have those concrete things to govern the United States and then the rest of everything goes back to the states?
Because that's what's happening.
That's what's happening right now. So you had, and I'll bring it up since it really hasn't by its name, Roe v. Wade. It was a federal mandate, a federal opinion by the Supreme Court. It was reversed by the Supreme Court and said, states, you have control of it because we do not see this in the Constitution. We don't see anything here that says, yes, that this is necessary or that you have these federal protections. So states, you decide.
Punt.
And now you have so many issues. Women are literally in dire straits because it has been pushed back and to the states.
The whole idea of dual sovereignty, to me.
I'm a Texan in the United States, so that the students understand what that,
Yeah, well, that states and the federal government have their own sphere of sovereignty, and they exist simultaneously. And as lawyer to lawyer, if I'm putting together
They're charging us for this by the hour, by the way.
Pro bono for me, I don't get paid enough.
All right. I'm putting together a charter for a corporation, and my client says, it's me and John, and we want it to be 50-50. I'd say, don't do that. Because
Terrible idea.
you can't make decisions if both of you have equal power. Either give somebody 51% or bring a third party in and let them be the decider. So what we've got, when we look at this situation, that we we have the possibility of devolving very critical issues to states so that you have a cacophony of the interpretations of human rights. And
No comity of law.
And where does that take us in terms of whether or not the foreshadowing that we've seen in Roe and the cases that are lined up to be taken in this session, where the the absolute power of legislatures, what's the term? Okay. Anyway, the idea is that that the Constitution says that
Supremacy.
Oh, yeah. It's the supremacy of law.
Yeah, so
Well, you're thinking of a different term.
Yeah, there's a concept that they're working with right now, that the Constitution says the states shall pick the time, place, and the manner of elections. So they're saying that it says the legislature,
Yes.
so that nobody can contradict them.
Yes, that's in the Constitution.
Yes.
That they have the right to, they also have the right to, a voter, to
Submit.
design or what's the
Well, the
word?
qualifications of the.
Voter qualifications,
voters,
yeah.
Yeah, it's an enormous power, and now it's being devolved to states that some are Democrat and some are Republicans, whatever. So it depends upon what state I live in, whether or not I have certain rights. So where does that take us?
Pre-14th Amendment.
Yeah. I mean, it takes you back to a time with no substantive due process. So there are two types of due process that are kind of being hinted around here. There's procedural due process. That is, are the procedures and mechanisms set up in a way that's equitable? Okay? Then there's substantive due process. That's these situations that arise where you have something that is so fundamentally unfair but doesn't fit squarely anywhere. Right? This is how you get Loving v. Virginia, right? Where the Supreme Court says that individuals have an absolutely fundamental right to marry who they want. The state of Virginia cannot tell people of different races you can't be married, right? This is how you end up with Obergefell, the case that has the effect of legalizing same-sex marriage to the extent that that's what we want to call it. Again, because it deals with these nebulous issues of substantive due process. That's how you end up with Roe v. Wade and privacy. It's not in there, but we all fundamentally know that there is something profoundly unfair about the government invading some areas of our privacy, even though the Constitution doesn't expressly prohibit that. If we're gonna erode that away, right, take these things away, starting with Roe, and with the suggestion of Thomas, and by the way, this should get the irony asterisk of the year, he wants to undo substantive due process to put an end to a federally protected right to gay marriage. Of course, the next step would be to undo Loving v. Virginia and the federally protected right to marry somebody of a different race than you, which would put Thomas in an unusual position.
Yeah, he strangely didn't mention
He
that one.
was not on his case of
He wanted to
substantive
explain
due
why.
processes cases because his wife is not black.
Okay, so,
There's the irony.
so, racism aside.
Okay.
What you're saying then, I hear you making an argument that the entire structure should be redone.
No. What I'm saying is that the structure already supported a substantive due process conclusion. It was there. It already existed.
My issue here is that if you have these the only thing that I would change, I'll agree with a tiny bit, about the Constitution is whenever you have these Supreme Court opinions and decisions, there should be a next step.
There is. It's
Okay.
called amendment.
I'm aware of that. I'm saying actually using it.
Band-aid, keep going.
But that's a political consideration, isn't it?
Okay. Yes, it is, and that is the entire issue that, I'm trying to bring in here is that you can't rewrite the Constitution in its entirety because there is no system that would allow for a nonpartisan Constitution. It wasn't there at the beginning. It's not going to be there now. Because even now, we are even way more divided than what we were whenever it was just two parties, and even those two parties weren't official until after Washington leaves office. Okay? And those of you that are thinking about, Washington's farewell address saying, oh, don't choose political parties, he was a Federalist. Okay? He was already part of it, but he just never said it. Okay? He is the only person in office that does not align, but he aligns afterwards. So political parties have been part of the Constitution and building the government since the beginning. You can't sit there and try and redo the entire thing, but those amendments, those opinions can help then solidify it into law. And the reason why that's important is because it is much, much harder to repeal an amendment than it is to overturn a Supreme Court decision like Roe, like privacy.
Let's step
For a generation.
Let's step off into a fairly deep,
We're not there
Sure,
already.
why not?
No.
Racism aside.
6
no.
questions.
this goes beyond where we've been.
Okay.
It is the concept of justice
Oh, what's that?
and equity and the.
Wow.
I don't know what
If
that
we're.
is. Go for it, sorry.
No, that's a good comment. You don't know what that means.
I don't know what equity means. What does equity mean?
Of course you don't. Because it's hard, it is a slippery place. But I look at it, or as a conflict of logic and justice. You can have things that are absolutely perfectly logical, but the outcome is unjust. So we've got Supreme Court decisions that are trying to use very strict logic, the four corners rule for lawyers, that you have to find a meaning within the document itself. And only if it is obviously ambiguous can you go outside and say, what does this mean? What were their intentions?
But was justice or equity ever a point of the Constitution?
That's my point.
For white men.
I mean, I don't see it there. I mean, it's only been back to, it's been added through amendments, and most of the times that it has been added through amendments, it's been added in a negative way. You can't stop somebody from voting because of these things rather than saying these people can vote, which is what opens up Jim Crow and all the stuff that comes after that. I mean, I don't see justice and equity as something the founding fathers would have cared a whole lot about.
The Constitution can be viewed like the Bible. There's an Old Testament and there's a New Testament.
13th, 14th, 15th is the new revolution.
Yeah, that's right.
That's the current historical interpretation,
And
yes.
the Old Testament only talks about freedom and order. Only with the New Testament does it start talking about equality.
That's why one of the main
I
historical
mean, not for
arguments about
nothing, it
now
does
is
say,
13th,
we the
14th,
people, in order to form a more perfect union, establish justice. I mean, I don't know that
Who
we
is the
can.
people?
Yeah.
What is
Well,
justice?
So-
That wasn't, I'm not saying that's being asked.
Who are the people and what is justice?
I'm not suggesting that that means that the term is well defined, but I do think it might be not wholly correct that they didn't consider things of justice. It's just what justice meant then may not be what justice means now, to the same extent that what justice means to these students sitting in here right now probably wouldn't mean the same to a group of students sitting in inner city Detroit right now.
Good point.
So who gets to tell us what justice is? Because if it's a fight between Michigan and Texas on what that means, the only people that are losing are the citizens of Michigan and Texas.
I go back to what I said before. I don't think we need to redone it in 2022. I think we need to redone it in like 1820 and then again in 1840 and then again in 18. So we would have the, yeah, I agree with it, what everybody's saying right now. Like now it's too late. I mean, now you either have a revolution and scrap all of it and start over, or you've got to somehow make what exists now work. That's your two options at this
We
point in
don't have a
time.
way back machine.
No,
Right.
Can't go to
that's what I mean.
the
I mean,
house.
now that's why. Is the Constitution out of date? And I said, yes, it's out of date. That's why I say it's out of date. I mean, we've lost our chances to make it in date.
Really.
That's my feeling.
Well, and the reason why they created this new constitution goes back to what you just said and read, is to form a more perfect union, because you have to look at what was it before. The Articles of Confederation established the union, but it wasn't perfect. Things happen. Hello, Whiskey Rebellion. Things are gonna happen, and yes, I agree. Jefferson had it in his mind that this is not permanent. But we have to, again, not listen to the ghosts. I will agree with you on that. Is he saying that amendments need to be added in order to keep up with the times? Or is he saying keep scrapping it and restarting every generation? There's a big difference here in, what this means today, because are we saying, if we want to listen to the ghosts, if, we want to be like Scott over here and, start quoting Thomas Jefferson every time,
No, the zombie
Behooves
founding
us.
fathers.
the partier of the first generation. Are we going to say we need to just keep on changing it every generation? So essentially we're saying, hey, every time we have every fifth president, let's rewrite it. Essentially that's what that is, every fifth president, even if all those 5 presidents serve 2 terms. Every fifth president, and now then you're gonna have those issues of, don't worry, in 20 years, in 10 years, the next president, let's make sure we get all of our ducks in the row. I'm gonna start raising my kid to be in that generation.
Well, but the good thing is they did succeed in creating a perfect union because we have no problems now.
That was a perfect
I don't
union.
think that
I mean,
Hang on, that was a perfect union. Then what happened with the Civil War?
it says a more
It set up the Civil
perfect
War. The
union.
It
Constitution
does not
created
say,
the
it
Civil
doesn't
War.
say the perfect union, a more perfect
The
union.
Constitution created the Civil War.
Absolutely it did. And my students will learn about that next week.
You can't have you can't have the Civil War without the Constitution setting up the split between the North and the South, which is reflected in the debates they had to create the
Yeah,
Constitution.
yeah.
So to create a perfect union, they included something that allowed it to fall apart.
Well, I think that what also we're kind of talking about is the fact that where we are is not an island, it's a continuum that started with the colonial rule and, 160 some odd years of building up institutions and wealth and place, and then to be told, well, by the way, that's mine, and we're gonna tell you what to do with it. Is it perhaps a property issue, a wealth issue, a power issue, as it has ever thus been? But then, we had the revolution, we had the Congress, which just was dysfunctional, so they said, let's fix it. So they had a constitutional convention, and what happened? They said, let's just burn this dude and start over, which is probably one of the primary fears that we have about having a constitutional convention today. How far does it go?
I think one of the important things that going back to liberty, right, is that whenever we wrote down, I say we as if I'm part of that first generation, that, life, liberty, pursuit of happiness. That was not the original phrase. The original phrase, John Locke said, life, liberty, and property. But, the first generation said, no, that doesn't sound so good because property means so many different things. Because what that says, life, you have the right to your life. You have the right to live as you want, that liberty. And the right to have your property as you wish. That is what the intended phrase was for. But then it's the pursuit of happiness. And God, that can mean so many different things, right? And it sounds really good. It's propaganda. And so whenever we take away that property aspect of it, it's included in every other amendment, every article, every section, property is in there. And of course, that is what's going to inspire the Civil War, because property to this first generation and the second generation and the third generation all include slavery. Slaves were property.
I'm going to assume, though, notwithstanding the concerns of slavery, that you are not suggesting
Of course, I can do
that
whatever it is.
somebody's interest in their property, that which they've acquired through work and otherwise presumably legal means, shouldn't be protected?
I'm saying they left it out to be ambiguous about it.
Sure, why, I still don't understand why that's a problem.
Well,
Time machine, let's go back and ask them.
I don't know.
That was, I think, one of the original PR jobs. Where they said, that's not gonna sell.
It's
You
not,
know?
yeah.
If we say property, they're gonna go, I don't have any property, why should I be for this?
Well, those people without property couldn't vote anyway, so it didn't matter.
Well, they
Well-
still had to have political support.
Bacon's laws, yes, they could,
Hmm?
at least in the colonial reference.
Yeah, but I'm talking
My
like
sense about that.
in the states as they create afterwards, it's property that determines who gets to vote and who gets to run for elections and who gets to have their voice heard.
I think it was very good move to make it less comfortable still. Then too, I think that what's always been kind of pointed for me is the concept that many people have that convention was over, they all locked arms and they went marching out, you know, all for one and one for all. I don't think so. They were in a hot, sweaty room and they'd been at it forever. And so they finally said, I can live with that.
Lots and lots of
I can live with that. Oh, I can live with that. So, okay, let's compromise our way out of the room. And that's where we started, is we compromise.
Yeah, but we started by throwing away the thing we didn't like before.
Yeah, we started with a bunch of drunk guys in a room writing a constitution, and we're still trying to keep ourselves there. Like, we're still tethering ourselves to this thing. I think this is Scott's point. If we're talking about, like, American politics being on the spectrum here, right, and this is our original tether, maybe our tether's moved, because we're out here now, we're trying to, like, make this thing stretch and fit. Maybe we need a new tether that's, like, closer up here, right, so we're not stretching this thing quite as much. This democratic pain you're seeing right now in the Supreme Court and the Senate, all of this comes back because we're trying to stretch this thing to make it fit a time. It was never intended to fit, right? We're still trying to tether ourselves to this room.
Why in the world would we do that?
Would we do it?
Try to stretch it? Why do we?
I don't know. I don't know why they're trying to do this so
When you
hard.
consider 230-something years of the existence of this great experiment we call the Union, that we only have 27 amendments, that's pretty good.
Yeah,
But
it's
how
hard
many-
to pass
how many
amendments.
acts?
What
It's not
number
because
are
we
we
passed
on?
the ones we
How many
considered.
acts, how many Supreme Court decisions? Guys, I'm a centrist, so I'm like right in between these guys, so, but against you. The issue.
It's a good place to be.
Oh. 27 amendments. One of them is to repeal another amendment. 3 of them is to give rights to things that should have been given rights to in the very, original document. But how many acts do we have? How many civil rights acts do we have, Daryl?
Lots.
And why do we have so many? Because we
those.
ignore the original. The Civil
We
Rights
also ignored
Acts.
the 13th, 14th, and 15th amendments for a very long period of time after we passed them.
And still sometimes.
Well, you have the
we
Civil
say
Rights
And-
Act
and
in
a lot of times
65,
now,
the
too,
13th
yes.
Amendment, 14th Amendment, 15th Amendment, and then we have the Civil Rights Act in the 70s, then we have the Civil Rights Act in the 60s. All of them are saying the same exact thing as that first one, but we don't listen to it. It's been a generation or two, and we forgot about it, so we have to say it again.
But the amendments form the basis for the legality of the law.
Then why not make that an amendment? Why not make it? It's been
Because it's not a
60 to
fundamental,
70
because it's
what,
not a
70 years?
fundamental principle.
No, because
Not
it's
now.
politically inexpedient, be honest.
Well, I'm trying to be honest. It's not a fundamental principle.
It's politically.
You don't put that in a constitution. You put that in laws. You put the laws to be specific about and use the fundamental principle.
It's already in the law.
Yeah, but the laws, the Civil Rights Act, the Voting Rights Act, all of that was based on the 14th and 15th Amendment. So
They're-
you already
but
have a
they're-
basis
so
to
there's a
pass the
constitution.
law.
And what happened to those civil rights laws?
Which ones? The ones that were ignored and tramped on?
Why do we
and-
have to have new ones? What happened in the interim?
Because they kept on forgetting about it. You have the non-enforcement of these acts and of these, these amendments.
Did the Supreme Court play much of a role in that?
Absolutely. Plessy v. Ferguson, separate but equal.
Because they reinterpreted it.
They're okay. I'm not gonna restate things I've already said. I'm gonna stop doing that.
That's okay.
We want to get people to ask questions, you think?
Sure, yeah.
You guys wanna-
I'm having a lot of fun.
I know,
I know.
Take care of the fun.
Does anybody have any questions they'd like to ask?
Just to rile us
Or
up
do you
there.
want to just see us keep this going for 10 minutes. Please ask a question.
Please ask a question.
Anybody?
So we got a
We
question.
got a question front.
My thinking on this is, let's say we do have to rewrite, have to kind of just start from scratch. We would have to have an equal number of conservatives and liberals, or else the liberals are going to feel screwed because there's more conservatives and vice versa.
Like
The
me?
problem is, right, we cannot decide on anything. So how are we going to rewrite it if we can't decide on what to put in it?
We can't.
Exactly. So it does no good to even try to start over.
Well, you may not be able to do it in this current political construct. I mean, I don't know that this political construct is something that is in perpetuity, right? It could be a schism, we just don't know yet, we haven't had the time to analyze it. But, if you can't do it now, that doesn't necessarily suggest it wouldn't be available as an option in the future. But you're absolutely right, it's overtly and overly political right now, almost to a fault. So I don't know how you could have an honest discussion about government structure. And the truth is whatever we redo is probably gonna look vaguely similar to this anyway.
Mhm.
If there
Just with modern terminology.
Maybe.
And if I may, I'll address your point as well, right? Because I think somewhere along the line it got ascribed to me that I was calling for a nonpartisan constitution. I know that's not possible. I live in this reality, okay? I'm awake. I'm not under a rock. That's not at all what I called for. I understand that politics is partisan. Politics is partisan when they wrote it in the first place, right? We can do it. I'm not saying it's going to be easy. Anything worth doing is going to be difficult. I feel like the attitude right now is like, it's going to be hard to write a new one. Let's not even try. Right? I'm sorry, I don't have that defeatist of an attitude.
Well,
right?
and the other side of that too is that if it's hard to create it, that doesn't
That
mean,
one-
if it's hard to change it, that does not automatically mean that what's there must be good because it's hard to change it into something else.
Any other questions? Dr. Peru?
So it seems like the Constitution is the only thing that has a large call for reform, but why aren't we perhaps reforming the executive branch? Why is there just one leader and one vice?
That's in the Constitution.
Well, but I see what you're saying.
Yeah.
You're talking about the difference between changing the whole bloody thing or
Yeah.
looking at specific aspects of it and saying, this is what we need to correct now, this is what we.
Like introducing term limits in Congress.
Right, I mean, those are valid questions, but remember, we talk about politics often without really talking about what that means. And in my class, politics is the acquisition and maintenance of power. That definition fits in context outside of government. If we accept that that's true, then convincing politicians to cede power,
Never happens.
good luck.
That's why gerrymandering will never be fixed.
Right.
The people who can fix gerrymandering are the people who benefit from gerrymandering.
The people who could give us term limits would not benefit from term limits.
And those people who get elected on platforms of fixing term limits tend to stay long after the term limits that they said they were going to vote against.
Then
Not
let's,
only
let's
that.
not
Yeah,
let
true.
let's not let Congress write the new Constitution then, because clearly they're greedy, ambitious pricks. So let's not let them put the like let's sorry let's put somebody else.
But-
We just earned the E on the recording.
Yeah, sorry.
There is nothing in the
Is it clean
Constitution
from there,
that
Larry?
tells us how to hold a constitutional convention.
That was a good question. We got
That is
another
a
one?
great question.
Yes, ma'am.
Kind of going back to your tether idea of like where we need to create a new one for the Constitution, would you not say that in your opinion, do you think the amendments are lengthening that tether itself to make it fit better, or not?
Was that for just anybody?
Yeah.
Yeah, no, I think that's an excellent question. Yeah, so you would suggest, right, the amendments sort of draw the Constitution more towards our normal, you'd
Yeah,
say?
because you said that we're stretching it out, so
Yeah.
do the amendments to stretch it.
No, that's a really fascinating point. I think my fear would be that any of these amendments that you put out here that draw us closer to where we live in 2022 could easily be overturned, right, and taken back. And so I guess the temporality of that sort of worries me. But I think that's a fascinating point.
I'm not sure history supports the idea that it's that easy though.
Oh, no, yeah,
You know what I
well,
mean?
it's possible.
It's possible, but.
Well, but again, going back to your point earlier, There have been way more court decisions and acts and stuff like that that we've gone back and forth over and over again than the amendments. And honestly, those create more of what the Constitution is today than the amendments do, because it's how do you interpret those amendments is what actually makes the Constitution what it is today.
And proof, it is proof. What you just said is proof that the majority is not always right.
So you're saying you're
It's just
not
the
right.
majority.
It's just the majority, but hey, the majority said separate was equal at one time in this country.
I'd like to know each of y'all's opinions on because the Supreme Court deemed that they had the sole duty to interpret the Constitution. What, or how would you feel if there was a second institution that had the same job and they colluded together and talked about it, instead of just one institution?
We do.
Let's
It's
get
the
those.
upward progression of the appellate process.
Correct.
So you start at a trial court level, and let's just keep it federal for right now. Start at a trial court level, they make a decision, whatever it is that comes out of there. Someone usually says, you violated my rights under X, Y, or Z provision of the Constitution, and we jump up a level to an appellate level. That appellate level then looks at what the court below has done and makes a decision. You either were made the right decision consistent with the principles of law, principles of the Constitution, yada, 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 or you didn't. Then we wait. Are you going to appeal that? Are you still upset? And if you are, we move up a level. Eventually, where do you end? You end at the Supreme Court. The Supreme Court now has trial court to them explanations of everybody's interpretation of the facts, everybody's interpretation of laws, the attorneys, amicus briefs, friends of the court, third parties that are semi-interested but aren't necessarily actually in the lawsuit, the courts themselves, the attorneys of the parties. You end up with a truckload of data
And then they
for
vote
each
as
one
they
of those
want.
cases.
And then they vote however they want.
Exactly, then they can ignore it all if they want to.
Yeah.
And I think the.
But again, yes, they can.
I mean, I'm gonna speak as
So why is that a problem?
I'm
No,
gonna
I
speak
don't,
for
I don't
the-
think they're ignoring it, because any opinion, whether it's the minority opinion or the majority opinion, they're still using the Constitution or their interpretation of the Constitution as the basis for their opinion. So they're not ignoring it.
Right. I agree.
They just may be stretching it.
They're just abusing it.
Whenever judicial review first came out, it was because a state legislature had decided something. And you're in my class, you'll learn about all this later. Okay, when the state decided something, the Congress said, wait, is that legal? Can they decide something? Because it had to do with the federal government. And that's whenever the Supreme Court and John Marshall said, wait, no judicial review. We don't believe that what the state is doing is legal based off what the Constitution says. That's the checks and balances there, right? So there is some kind of, not equal decision-making, but whenever the state is saying something, that's usually what ends up going up to that Supreme Court, is whenever the state government, their highest level, will say something they don't agree with, it, then they take it to the federal level.
Well, to get back to your original question, one thing that doesn't happen, actually what happens is that the Supreme Court decision is final.
Exactly.
And what doesn't happen is, you don't ever get a chance to say, well, if you didn't like that, let me try again to do this, except then it's 8 years later, because that's how long it takes to get through that entire process that Nick just talked about there.
Or you can look at it from this perspective, the minority opinion of the Supreme Court sets a precedent for a later majority opinion to overturn.
But I'm just saying that the issue is that we have the Supreme Court as this, it rules something, every single thing goes away that it ruled against at that point in time, rather than, well, let's toss it back to the legislature, or let's toss it back to the executive branch to try again, or to work, to try and work things out. I'm speaking from a historian perspective. I am not a government instructor. I am not asking how you do that. I'm just saying from a historical perspective, it's like, why not? Why not have it to where that is? Because it seems to me like you are still giving 9 unelected people the right to do what they feel like based upon who happens to be there, based on which presidents happen to have Supreme Court justices die while they're in office.
Another question?
Are you all saying that the Declaration has basically betrayed us?
The
Or
Constitution.
the Constitution, that's what,
Has betrayed us,
and it's just not working anymore?
that's what he's saying.
No, I think it works just fine.
I think it works, I think it works fine for the people who benefit from it.
Well, that's all of us.
Yes.
Okay.
I think whether or not you think the Constitution works, as you can tell, is radically dependent on your interpretation of its purpose and whether or not it's a purpose. To the extent that the Constitution's purpose is to provide us with some kind of sense of order or structure, at least to that extent, it works. It may not always work really well, right? But I haven't yet heard an alternative other than it might be worth changing. But I don't know what that would look like yet.
I don't know if I would say it's betrayed us. I would say that as society has evolved, right, and that's the biggest issue here. You know, from 1789 to 2022, society has evolved. And the question here today is, does the Constitution represent society today? And using the amendments and trying to get it to be a representative constitution, representative form of government is the issue. And to that point, I do not believe that it is representative, but I don't believe that there is any other option than just more amendments. Instead of Supreme Court decisions and acts, amendments is the way to
Time
make
for
it.
one more question, you wanna do that?
Do them in.
So, like with the Constitution and the Civil War, if hypothetically we did toss it out and start over, what is the likelihood of a second Civil War?
High, very
Extremely
high.
high.
It's extremely high without even that scenario.
Yeah.
The Republic is in extreme danger right now.
Close to zero.
I want to make something.
Close to zero because in order to engage in that, you have to presume that a sufficient number of citizens are willing to pick up a rifle, walk out their front door, find somebody, maybe in their neighborhood, that they disagree with politically, aim the rifle at that person and pull the trigger. And yeah, there are a handful of people that would do that.
If you have a neighbor in mind, he's talking about you.
And there are people that might do that. But to the extent that that's a nationwide civil war, close to zero.
All right, we've had I think, a very lively and productive thing. I think it's productive. And the question is that the Constitution